So, good afternoon, everyone from India. And I'm glad that people have joined throughout the Commonwealth for the sixth and the final session of the CLA AI technology session, which is on the topic AI, artificial intelligence, and access to justice. And to introduce the final webinar today with us, we have the member from Kenya, Maria, who's going to introduce and who's going to make the remark for introducing the final episode of the lovely and I think, more knowledge driven series pertaining to law and technology in today's time. So, Maria, over to you.
Thank you very much, and good afternoon from Nairobi, Kenya. Thank you, Sid, for that lovely introduction, and welcome to you all from across the world. My name is Maria Mbeneka. I am the co-convener of the CLA Tech Law Committee, and today we are very, very excited to be hosting the last part of the first series. This is a series that was conceptualized by the CLA Tech Committee, and one of the presenters is also my co-convener, Amirali, and he's based in Hong Kong. We also have Julien, but Julien is from Rwanda, but I'll let Sid do the introductions of your speakers today. My work here is really to tell you that we are very excited as a committee to be able to have brought you this wonderful webinar series. Everybody today is talking about technology and technology law, for everyone who's in this area of practice or not in this area of practice is almost a must because we're dealing with technology, whether we like it or not. I'm really, really proud to see that we have a lot of participants all the way from Jamaica, Ghana, Rwanda, Trinidad and Tobago, the UK. We have participants from Pakistan, Rwanda, I said Rwanda, Canada, France, not France, the Faroe Islands. Wow, that's very, very interesting. Hong Kong, really Australia, all over the world. And I'm sure as they join in, they'll find a very, very exciting last episode of the first part. We have my fellow Kenyans coming in strong there, as well as Malawi, Papua New Guinea, the Maldives, and a really rich mix of participants. Cameroon, you're very, very welcome. And Zambia, I can see we're still growing in terms of participation. This is really what the Commonwealth Lawyers Association is about. And those of you who have joined us today who are not yet members, I'd really, really encourage you to join the Commonwealth Lawyers Association. We're a great mix of lawyers, as you can see, from even our panel to what we do as an organization. We have the upcoming Malta conference, which is going to be next year in Malta. That's the biannual conference that we have every 2 years. We're going to host it in Malta. So I'd encourage you to join as the CLA as a member so that you can benefit from the wonderful work that we do. Before I go off, I'd like to also let you know that we're joined by the Secretariat, that is Evie Wilson and Claire Rowe, who are the power behind the scenes and make sure that we keep going. So without further ado, I'd like to welcome Sid, who's also a committee member of the CLA Tech Committee, to take it away with our panelists today. So enjoy yourselves and make sure you ask questions and make sure you give feedback. We really, really like to hear from you. Welcome.
Thank you, Maria, for this wonderful introduction, because I think it's very personal to us because we have all worked hard to make this series successful. And we're also very thankful to all the persons who have been participants and who have taken out time to come and share their expert opinion with us. And today's topic is most important. Today's topic is a topic which is creating a lot of confusion because we have seen how the time have progressed. We have discussed, like as a student of law, when we could not even imagine AI, was because we heard from our seniors that they have to rush from one court to another court in India specifically to attend to their matters. They had to read a lot of files to find a president. And now president is sometimes a click away. And the definition and the meaning of access to justice in itself has changed its meaning during the course of the time. Because at one point of time, access to justice was a topic which was introduced for making human rights reach the the marginal section of society where they did not have voice to be heard. And court played an important role to give voices to those citizens which were invisible but yet important. And now in the 21st century, one of the most important thing and recent development is the development in artificial intelligence. We have online courts. I think access to court where people used to travel for an hour to reach court. Now court has become accessible by single click. You can talk to the judge. Your president search is one click away. Or you can, nowadays people also go on Chat GPT to find out some rulings which would favor their clients. And fortunately or unfortunately, Chat GPT also gives you an answers which appears to be true, but when we dig into it, it turns out it sometimes turns to be false. We have seen recently in America where a lawyer had cited a case law from ChatGPT, and that case was considered to be completely fake. So at this moment, the question pertaining to AI becomes relevant because there are advantages and disadvantages of AI. There is biases which can be filled in. The idea of a machine, and there can be data privacy concerns, there can be ethical concerns with respect to AI, and most importantly, when we talk about mediations or cases which has to be decided by a president, that's all right, you can fill in the information and you can have an answer, but there are laws which requires exercise of discretion of an individual, and that is where the questions pertaining to exercise of discretion become relevant. And can the machine actually exercise discretion which is free from bias? And in today's discussion, this is the central point, that whether access to justice through a model of AI, what are its advantages and disadvantages? And today, to discuss it with us, we have two important members of the CLA with us. We have Amir Ali and Julian. And Amir, to introduce Amir Ali to our speakers, Amir Ali is a council member of Commonwealth Law Association and Vice President of the Law Society of Hong Kong and Chair of its InnoTech Committee and Guide to Professional Conduct Committee. He's a practicing solicitor with a blue attitude to the planet who enjoys neuro gaming in his spare time. And during the course of his session, I would request to put some more light onto it because I'm very interested to understand, and I think viewers would be to understand what blue attitude to planet would mean. And now we have the second speaker is Julian. Julian is a senior partner of the corporate law firm in Kigali, Rwanda, called K Solutions and Partners. And he's also the past president of the Rwanda Bar Association. He's the council member of Commonwealth Law Association as well. And today, to moderate this session, I am Siddharth Sajoria. I'm a committee member of the Law and Tech Committee of the Commonwealth Law Association. And I'm also serving currently as the co-chair of the Young Commonwealth Bar Association. And now I would request the panelists that during the course of these arguments, if they find something very pertinent to be raised as a question, then please don't hesitate and put the questions in the Q&A box. And now I would invite Amir Ali to come and share his session with us today. You're muted.
Okay. Thank you, Sid. Thank you, Maria. I have a lot of slides, but they will be made available. And I hope they are of use to you, but I'm going to go through quite a lot of material as fast as I can within my allotted time of 50 minutes, and I'll try to deal with any other questions by reference to my slides if necessary. So the important issues in the most important issue is that AI is constantly changing. And because it's constantly changing, we are not able to keep up with the laws that govern AI, especially those that govern ethical conduct for lawyers. And so my focus is going to be starting off with professional conduct. In our Guide to Professional Conduct, the Chief Justice, former Chief Justice Geoffrey Mars said the spirit of the guide is just as important as its letter. This is recognized by the guide itself. It makes a significant point that some ethical standards and obligations are higher than even the requirements of law. I think that's a good point to start with, because lawyers are faced with obligations which are actually higher than those set out by the law. So the advantage of the common law and common law principles to this ever-changing technology is that common law principles are developmental, and because they provide persuasive authority in our common jurisdictions, they provide a powerful tool to address the constantly changing environment that is faced by us in the use of AI, because that's developed by the engineering profession. Of course, these are the other principles, and I will be focused on the common law principles. In Hong Kong, we are faced as professional conduct. We have our private life is subject, if we are within acting as a solicitor, within the slots, within our professional life. Of course, we have to take into account the public interest, and there's always a professional conduct issue and disciplinary tribunal issue as well. So you can see in the ChatGPT case in New York, ultimately ended up in their disciplinary tribunal in their system in New York. What is really important is that we must protect the technology, because ChatGPT wasn't prepared for lawyers. It was designed as a instrument of art creativity, and that's what it is doing. Its design is to do that. So if we're going to use it, we should use it with an understanding that it is designed for innovative thought, to allow you to think of different ideas, which would take you a long time. So with that, another important point is for Hong Kong, and I know some of your jurisdictions are different, a standard of proof is on the preponderance of probability. So the more inherently improbable it is, then the more serious the crime or act must be. So that's the standard of proof that we use. COVID has also been an important game changer. COVID, I would say, means a change of values initiated by disease, but AI, I call it iCovid, means change of values initiated by design. And as the technology changes, and so values change by design of those who create design in law, design in engineering, and it's a very fast-moving part. So AI in law firms, you can see it's now growing. AI in magistrates and judges. In Hong Kong, we don't have AI, but we have technology which looks at the decisions for sentencing. For certain types of acts, certain types of consumer trade, perhaps an AI would provide access to justice below a certain level, say $1,000. If you have an AI, at least it allows people to have access to justice and some sort of landing page. So in some parts, it is actually important. And you can see here various other areas that are amenable to AI at some level, so that you can get access to justice. And also AI should and possibly could be made available to law firms as well. In Hong Kong, I look at our principle, two of the rules of solicitors' practice rules, which really talks about a solicitor who is in the course of practice as a solicitor shall not permit to be done on his behalf anything which compromises, impairs, or likely to compromise or impair his independence, the freedom of any person to instruct a solicitor, duty to act in the best interest of the client, his own reputation or the reputation of the profession, and a proper standard of work, and a duty to court. I'm sure this is common to all of you, and it's something that is important. For our part, in our Guide to Professional Conduct, we've addressed technology in Principle 1.07 of the guide, which says the solicitor using information communication technology should endeavor to ensure within the parameters of technology, information and knowledge available at the time of use, that no principle of the guide or provision in practice, directions, or applicable law is breached by such use. It's very broad, but we then give you a commentary on its use. It's based on available information and knowledge available at the time in order to determine whether or not to adopt a particular approach to the use of what we call information communication technology. And we also follow non-mandatory guidelines, for example, our ISO 17799 and 27001. And I think many other law societies also have adopted these standards as non-mandatory guidelines for our members. Principle 8.01 talks about electronic communications. So one of the interesting areas is in our professional guide, we have Principle 8.03, which is similar to all your common law jurisdictions, which says that it applies, for instance, it says that you have to disclose any information that is relevant to your client's matter. You also have this system which says that if you deliver something by mistake to the lawyer on the other side, it talks about document, but consider what I've just said, Principle 1.07 and this Principle 8.03. Now remember the Albert case, which is common to all our jurisdictions, applies to all our Commonwealth jurisdictions in that if you send the wrong document to the opposing side, they are not supposed to open it, and they're supposed to inform the client, and of course that the injunction may be obtained because of the confidentiality nature. Now, if you extend that by Principle 1.07, then that should extend not just to a document, but to email, media platforms, and any other form of communication, including AirDrop, Bluetooth, RFID. So if you were to apply 1.07, it's much broader. And of course, we've got other provisions as well, which we have judiciary's practice rations for the use of technology in court. And all of those would be open to Principle 1.07. So you can see it's quite broad. And then I've started to look at other areas. We have to apply technology in remote hearings, which we all do. And in doing that, we have to exercise care in looking at online banking when we use it within our firms, cloud computing. And now, as we have more and more AI, it is already operating within your computing system. So how does that apply? So we've got circulars on our cloud computing and the use of solicitors. We've got circulars on digitization of documents in Hong Kong. And of course, we've got laws about electronic and digital signatures under Electronic Transactions Ordinance. All of those become relevant. These areas are also important when you look at the way solicitors use and adopt cloud services, PaaS, SaaS, and IaaS. And when you're using that, you must take care. Remember, AI is already operating at these levels now. Also, when we're dealing with creation of smart contracts, it's important because then if you have a program that's running a smart contract, but if you have AI within the drafting process, then you have to make sure the lawyers understand if they're participating in the creation of a program that creates smart contracts, that they understand the parameters of that. And of course, you now get AI that will be drafting these programs, and therefore that's one more level of complexity. So these are some of these issues that should be bear in mind, I think, for my part. When you're using AI, you must make sure that the code, the algorithm used or adopted does not breach any confidentiality, privileges, intellectual property, and discrimination. I think that's important for us as legal profession anywhere in the world. When you're using AI, you must take care not to ensure that clients' data and any information input does not become part of the AI LLM. How do you actually do that and without understanding that system? So when you're using AI, use a risk-based approach in order to consider the risks and then classify those risks. And I think these are already implemented in the EU AI legislation to a certain extent. So those are some issues that you may want to consider. Again, when using AI, you must make sure, I'm sorry, this is, that, so for instance, when you're using ChatGPT or similar AI programs, you've got to take care that it does not impact confidentiality, privileged material, or again, it becomes part of the LLM. Again, for ChatGPT or similar programs, you have to make sure that you understand the nature of the program before using the same for professional services for clients and courts. It's very easy to now get different AI programs in different jurisdictions, and they're constantly developing. Again, when using AI or similar programs, a solicitor must not use or cause to be used prompts which create a deceptive response. So deception, how do you actually do that? One was the ChatGPT in used in New York, because it was deceptive in a way, not understanding the data of the program and then not checking whether that program, what it had created, was actually true or not. But again, I say that you should protect the computers because that's what they were designed to do. That's what the creator designed it should be doing, right? Next one is when using AI, solicitors should assess the bias and effectiveness of automated systems. So what biases are within those systems? And they vary from different jurisdictions in the way that those AIs are created. Consider, and because we are coming from different jurisdictions, in Asian systems, they're different. In European systems, they would be different. In African systems, they would be different. What are those biases? And I think it's important for us to see how those biases develop and make sure we disable those biases if we can. It's actually built in. So what's our role in the ethics? Again, a solicitor should not allow biometric to be used without the informed consent, because everything we do now for AI is a collection of biometric data, right? From everything, including my voice here. I mean, we have programs in Hong Kong where from this 15-minute talk that I give, they would be able to reproduce the rest of my material in my voice and tone. Not perfectly, but if I were to give a training for an hour or 2 hours, it could just create anything I wanted in my tone, in my voice, including the various tones that I have. And that's how quick AI is. So should we allow biometric data to be used? In fact, it's already being done. What about the use of algorithms that have bias scoring systems and systems that produce bias and discrimination? Do we have the ability to check that? Because we as lawyers must make sure that we do not allow those systems to become part of our legal services in any form. Another one, a solicitor firm must not use or utilize deep synthesis technology and services for professional services for clients. We may do it intentionally or unintentionally, but again, I go back to Principle 1.07 and see how it's been drafted. And whether that would need to be changed with the introduction of AI and its various permutations. And I'm sure those permutations within a year from now will be totally different. Okay. Again, this one talks about deep fake programs and algorithms, which are increasing. If you're going to use it, should we allow sandbox to be used to test the automated systems? Should we consider tools or services which are in breach of any of the principles of the guide? That's in Principle 1.7 actually looks at that. And if you're using black box models, you've got to make sure that the inputs creating outputs are not in breach of the principle to the guide. And so when we come to black box models, they become more complicated. And when you have AI that works within the system so that whatever you input, the AI takes it and develops it further, it's basically now you have to move towards which kind of inputs you're putting in order to achieve a certain output. And so our professional obligations would then go to how does the actual black box work, which is actually not possible when you have AI. We don't even know how the AI is going to be working, which is what I predict would happen in 2 years' time. When you're producing submissions to court, I'm going to stop at this one. A solicitor should obtain the informed consent of the client and inform the court that such a system is being used, and to use a white box where possible to explain the decision-making process. So as I said, there's quite a lot to cover. My slides are available, but I think my time is up. And so I'll stop here, and Siddhartha, I give it over to you. Thank you.
Thank you so much. Yeah, thank you so much for this wonderful presentation, Amit. And I think it's very important to focus on the ethical questions and even the idea of access to justice and the points that you discussed with regard to the ethical concerns that are there. Now, I would invite Julian to please share his views, and Julian is going to discuss about the advantages and disadvantages of AI when it concerns the idea of access to justice. So, please, Julian. Julian, you are muted, so I would request you to kindly unmute yourself.
Thank you, Sid. Do you hear me?
Yeah, now we can.
Okay. So we've been saying that artificial intelligence is becoming a new trend, and it has advantages and disadvantages in our sector. We have to deal with it, and some people are saying that those who will not be dealing with artificial intelligence in the legal fraternity may disappear. So one of the advantage and the reasoning is that we need to learn the advantage and the disadvantage as lawyers to be able to deal with it and move forward. Well, with those elements is the element of checking what can we do with artificial intelligence and how it can be allowing us to access more justice sector and improve the services that are being provided. So that is what we need to discuss for the 15 minutes we have ahead. And we'll be having an opportunity to discuss question and what is happening in your area, what is improving, and I will be sharing what is happening in Rwanda, because that is the country I know most. So artificial intelligence in that way is improving a lot with the access to justice, with interconnectivity, access to legal, can begin by this first element, or the efficiency and speed. So the use of AI will be efficient because it's a machine, it's not having any strike. You can have a result within seconds, not even hours, and usually lawyers are dealing with hours. Specifically, when you dealing with artificial intelligence, you want a quick result and accurate result, and that is what is being provided. And it is also cost effective, we'll be seeing it. So the cost reduction can go up to zero, because having it on your computer, having it on your mobile phone, you just ask a question and get the result. Getting a legal research, you will reduce the time spent by a lawyer or by needing of a legal expert to almost zero. So that is the efficiency and the reason why many people, for quick and simple legal question, will be using AI. But again, as lawyers, and the example City has been explaining, we'll be talking about disadvantage afterwards and the errors that can occur. So you need to be careful of AI and information being provided, and the quality of the AI you're using to be sure that you're not making any mistake and using accurate information. So that cost-effective system will be allowing people to access the legal information quite quickly using the ChatGPT AI, but there is also professional artificial intelligence that are specific to the legal fraternity that has a cost, but comparing the costs with the services being provided to the lawyers, legal fraternity, or companies, it's quite, it remains cost effective for them and for all of us in that area of law. So it will be enhancing the access to legal information, because you can access the information online within different jurisdictions. You can access database from India, from Hong Kong, from Rwanda, from Cameroon, from Ghana within seconds. And when you're using or when you're training your artificial intelligence within your own system or network of law firm. You can even access them combined, and the analysis will be done by the artificial intelligence, so allowing to even draft a legal opinion as quick as sending a letter, a simple letter of last reminder. So the access to the legal information, the access to accurate information, access to precedent, access to to have an idea of the likelihood of having a positive or negative decision by using AI is the kind of legal information you can now be able to use. So the improvement of accuracy is that when you're testing and using AI in a specific area of law, it will be also adding on his intelligence. So the likelihood of human error is not is reduced by utilization, the usage of the artificial intelligence. So using the legal research, drafting document, reviewing document, the AI will be able to review a document of 100 pages in few seconds and deliver an opinion and give you the key element or key provision you should look at, or draft a document and give you the key point should be in that contract. So the time you should be spending on that document drafting or reviewing should be reduced to almost half or a third of the time you are supposed to be using. So those elements is also affecting the cost, as we've been saying, because if it is speeding up the process, it should be allowing the judge to give a result quite quickly. It should be allowing parties to submit their written submission within days, not months, reducing the timing of the judiciary, where we are having usually a date of a case being postponed for years. So this is the element and the trends that will be helping people to go for artificial intelligence to enhance the legal research for parties and for judges deciding on a matter, even for arbitration or mediation, seeing what can be the alternative solution that are available on a particular case or in a particular mediation case you may have on the table. So it's not only in litigation, it's not only in transaction, it's not only for practitioners, even for our client, is becoming an alternative solution before reaching a lawyer or a legal expert. They are looking on the available ChatGPT or other artificial intelligence tool online. So that is the element we've been speaking. As we are lawyers, we have to see pros and cons. On the disadvantage, there is element to consider. Some of them has been specified by my colleague Amirali on the ethics and the element to take in consideration, the legislation that will be talking about data protection, but mainly here we'll be talking on what is the key point to be considering for legal practitioners. So the AI system are programmed, and it's a data collection, it's a data processor, it's a data transfer of information. So it can also have errors. It's usually limited compared to the human errors, but it has also errors or that can be depending on who has been having a control or testing that artificial intelligence. So if I have been testing the machine or the system using the database only in Rwanda, it may not be similar to DRC, may not be similar to Singapore, may be different from somebody in Latin America, because the culture and the system are not similar. Even the legislation are different. If you're in the Middle East and you have a case that is to be compared with a case in France or in UK, you may have a different decision, even if the fact could be similar, because of the way the culture and the people and the citizen, the legislation in that particular country will be practiced. So there is bias and fairness issue. So the AI system can be also keeping bias that are in a particular system, or bias that data has been collected, has been reflecting in the system. So those inaccuracy in the data can lead to problem of unfair and discrimination, as mentioned by my colleague Amirari. And as lawyers, we need to be quite careful with what is happening. Discrimination, profiling, Black, white, Asia, the collection of evidence based on AI we know that in some jurisdiction is already happening, where they can be able to have your face on camera, compare it with your ID card, compare it with your driving license, compare it with other information in the system related to your personality or you as an individual, will be adding to a profiling that can give you points, that can be allowing some right or limiting your freedom. So those elements based on bias or fairness issue has to be taken in consideration. And in Rwanda, there is a particular law on personal data and privacy protection that has been enacted 3 years back that is giving a kind of framework on the way the automated platform and non-automated platform should be considered when making decision or based on those artificial intelligence. So like the article, the data, the data subject has the right not to be subject to a decision based solely on automated personal data processing, including profiling, which may produce legal consequence or significant consequence to him. So if evidence collected has been only based on artificial intelligence, the judge should not be taking a decision based on that information only. So it has to be combining with other evidence or other statement or interviews or documentation that will be convincing the judge, not only based on a potential bias from the artificial intelligence. So we need a human intervention in this kind of system for decision making. So that is one of the disadvantage. The ethical concern, we've been mentioning it. Ethics, it's a very important element in justice, and artificial intelligence has to take it in consideration. It's not always the case, and human beings decision, human beings intervention, human beings reviewing has to be present to be able to make sure that the ethical concern are taken in consideration. So the sensitive or the empathy that is needed or a certain degree of deliberation and care has to remain key for us when making a decision, when advising clients, when a judge, an arbitrator, or a mediator is doing his job. So the data privacy and security is that when we are submitting information, of course, to the artificial intelligence, we are submitting private information. We are sharing confidential information. Again, Amirari has been mentioning this, so I will not be spending a lot of time on this. We can maybe discuss it during the Q&A, question and response session. But the main point is that the system is relying on vast amount of data, and it has to be effective. So if we provide data with bias, we'll be having, if we have garbage in, we'll be having garbage out. If we are providing key information and confidential information, it can be provided to some other people without our knowledge. So controlling the information can be an issue. So when sharing or reviewing a document provided by your client, please be careful that key information, key confidential, key secrets that are present in that system should be deleted before even testing an artificial intelligence tool. Because you sharing information that are confidential, you sharing client information, and there is guidelines to be careful with those. And it's quite key information to take into consideration. So potential economic and employment impact. Yeah, some people have been saying lawyers will be disappearing because of artificial intelligence. So far, lawyers or legal experts are not disappearing. Of course, they may have a certain reduction or a certain impact on certain jobs and creating other jobs. So there is IT people in law firm in the judiciary. We are in Rwanda, particularly where we have a system that is integrating the judiciary, lawyers, the prison prosecution, the Rwanda Investigation Bureau. We need IT people in those institution departments or even in our law firms to keep us safe and make sure that we are working using the tool correctly. So the potential economic and employment impact, of course, will happen, but the risk has been high for lawyers, experts. So the entry point for research and so that can be done by AI. To be relevant, we need to have an added value on those low-skilled legal jobs. But for law firm or bigger law firm that can use that artificial intelligence as a tool, it can be an advantage to be considered. So there is pros and cons on this point, and I've been explaining both, hopefully. So there is the regulatory and ethical challenges. So the fact that artificial intelligence is developing in the legal sector, the legal framework has to move and the policies has to change. In Rwanda, there is a national artificial intelligence policy recognizing the importance of artificial intelligence, but also recognizing the need to mitigate its risk. So there is a recommendation that has been made to make sure that the ethical guidelines are taken into consideration and that consequence happening in case there is errors done by a decision based on artificial intelligence, who will be responsible, who will pay the damages. So those are the elements the government of Rwanda has been putting in a policy and guidelines, and there is an authority that is in charge in Rwanda authorities and regulatory authority to make sure that these elements are taken into consideration by government institution, even private sector. So in conclusion, the artificial intelligence is quite key for access to justice. There is pros and cons again. AI is offering advantages in efficiency, costs reduction, greater accessibility, and affordability, but it has also some issues on the bias and discrimination that can come with the decision based only on artificial intelligence data collected. There is protection of information, there is confidentiality issue, there is ethical potential issue. We still need human lawyers to provide information when taking into consideration the responsibility and duties vis-a-vis the security and the privacy of information provided by client. So the artificial intelligence has to remain transparent, accountable, and people has to be mitigating all risk related to this new tool. So we can find the time to discuss the other question. I think the time ahead is now ending. And Sid, the floor is yours. Thank you.
Thank you, Julian, for the wonderful presentation. And I must say that I think one of the conclusions that can be drawn from Amir Ali's in your presentation is that it's a myth that AI will replace human, but humans who use AI will be a threat to lawyers who don't. So that can be the sum and conclusion of the amazing presentations by both of you. Now, like while hearing the arguments, that one thing that I was wondering is that we talk about biases. Now, biases that can be built into the system, those biases can create result which depends on how information is fed to a machine. Now, when we look at, I remember reading a very interesting book called Law and Justice by Jeremy Potter, where the important question that is put in the book is that whether the idea of law contains justice in itself. So whether the letter of law, can it be said to contain justice, or it depends on its interpretation. And where there is the scope of interpretation, there is the discretion. Now, one thing when we talk about public law, it's more about when we talk about access to justice in a larger term, or the larger meaning of the term. We talk about where discretion is involved, and because emotions are involved in some of the litigations, for example, social action litigations. So what are the views that, I mean, I would love to hear from both of you that firstly, can the element of discretion be given to machine to decide questions pertaining to human rights where emotions are involved? And importantly, that if there is supposedly a judge, like we have a system of recalling of the order, like if an order has been passed because of some, arguments which were presented before the court, and the arguments were not correct, so there is a chance of recall. So will that system of where AI is the decision maker, would that be considered to be so accurate that the idea of recalling of an order would be given a complete go or not? So I would like Amir, and then I would request Julian to please share your views on this.
Thank you, Sid. For my part, as I said, where the use of AI at low levels is very important for access to justice, because it allows for very small claims someone to land on something which allows them to feel that there's a system of justice that they can access, even if it involves, $100. They feel that there is something that gives them access to justice. So I think for that part, even now, small trades disputes, car disputes, accident disputes, many of these small things, AI should be available to them to give them access to justice. At this level, I don't think the AI can function at the level or the high level of domain that's required for intellectual capacity to allow discretion to be used. But I think if you feed in enough data to the AI, and there is sufficient data from all the court cases, then certainly there might be, but we'll see how that develops, because it's basically what program you put in. And even now, even if you have access to justice in the sense that it's an AI that's making a decision, you can always put in an appeal system to somebody else where that appeal process is available. Of course, that means it's back to humans and time and delays involved, and you lose that access to justice point. But again, I think it's important to have that. At the moment, it's not able, I think, to look at exercising discretion as a judge with all his mental capacity would be able to exercise. And after all, that is an important part of the system of justice. So as far as discretion is confirmed, unfortunately or fortunately, it is still in the human domain. But justice is an integral part of our law, be it AI or not. If it's not, then of course it can't be a legal system, because a legal system must be just. And the advantage, I say again, of our common law system is that we can rely on other common law jurisdictions because it's persuasive. And I think we can learn a lot from that.
Thank you. So mainly something on the emotion and discretion, the AI should be a tool, in my opinion. It should be allowing the decision maker to move fast and to reduce the cost of justice. So if the judge was supposed to take weeks to take a decision, it will be quick if it is a case of a small case of less than 1,000 or 100. It should be quick, it should be affordable, and AI should be a tool. Even for law firm, it should be a tool we use that to give a letter in 5 minutes and not cost the client 1 hour of our legal services, because that is cheap. Just checking that whatever document being provided using AI is accurate according to our experience, according to our knowledge, and according to the precedent we've been using in the past. But if there is a precedent being provided, we should be able, using our human and intelligence, human emotional intelligence, using our culture, using our added value in the networking, using the consequence potential consequence on a particular individual, especially in criminal cases, you need a human intervention to avoid just a machine taking a decision based on probabilities or on profiling, because you may have two people killing an individual, but will not be having the same sentence in a criminal matter. So accessing to justice need, yes, allowing more flexibility, allowing to move fast, to be efficient, but there is an element of a judge, there is a human contact that will be understanding the culture of the jurisdiction where he's taking a decision better than the AI itself. So that is particular because the AI may not be specific to that jurisdiction. So the level of emotion that is needed or discretion has to be taken into consideration, even if we do recognize that avoiding corruption, avoiding the human bias of a judge should be directed to the artificial intelligence, saying, this should be the decision if we have been using only AI. Why did you decide otherwise? That can be the level of the judge to be able to justify himself if the inspection of the judiciary is requesting to justify. But I'm still in favor of the usage of both. So keeping for decision, we need somebody responsible of a decision making. AI alone will not be responsible of any error or negative consequence happening by its decision. So I'm still in favor advocating for somebody responsible, but using AI as a tool. Thank you.
Siddhartha, I thought just to add in, it would be very interesting to see how in negligence cases, how an AI would determine loss of chance, because those are all probabilities. Would it be, I mean, it would be an interesting tool if somebody developed a hackathon and looked at loss of chance, and it would be very interesting too, because that's all mathematical, and it adds elements of discretion in it as well. And to allow a case to be presented to a body of human judges and an AI, it would be very interesting to see how the outcome would result.
The same in a family case, who AI deciding that the kids will be going to the father or to the mother without taking all the facts and the emotion going with it into consideration.
Yeah, very true, Julian.
Thank you so much. I think that was a very wonderful discussion on this topic, because I think this is something that would actually be discussed in coming times in the courts, then the AI would be having a far-reaching effect. Now, we have got two questions, and the first question is from Yoon Lee, and they ask that how does the common law presumption that computer output is accurate evidence apply to AI tools, or is there a need to change in law? So if you can read the questions. Yeah. If Amir Ali, would you like to answer this?
Well, actually, there's one question. The other one is just to share the PPT. As I said before, an AI at present, unless we have AIs that I know there are firms in Asia and in China that have developed AI specifically for use by the law firm using their own data within their own systems. And those are specific AI tools. And as Julian said, those are tools, AI tools used specifically for various functions that a firm may want to use for its various departments. But those AIs that are available to the general public, they are not designed for lawyers. Just as WhatsApp is not designed by lawyers, but we tend to use it for communication with our clients all over the world, it is not designed. Therefore, to try and input common law presumption to a system which is being developed for general public is not correct unless you tailor it specifically in its program, in its LLM, with elements which have within it the common law presumptions. It can't be done on those tools. But if you were to develop a tool which would have presumptions, then you'd have to design it to have those common law presumptions. How would you do that? You'd take all the cases we have all over the world on common law presumptions and see what you get, as far as the application of common law presumptions, because that's what it's about. It's about data. And that data is available in millions of cases around the common law jurisdiction. And it's just waiting for all those cases to be input into a system, which then tries to analyze using its LLM what a common law presumption would be. And it would be interesting because it would become a common knowledge, whereas we tend to use common law within our own cultural systems. Common law in England may now be different from common law in Australia in its use for its own cultural systems, as it would be in Rwanda or Nigeria or even Hong Kong.
Yes, it's always a matter of data collection and data reviewing analysis by a tool, by a system. So that collection is depending of what you want to achieve and who is collecting and the level or the amount of data you'll be collecting. That's the reason why there is maybe an advantage for big law firm that can have a specific department only working on collecting the data, having an IT department only working on improving the accuracy of the data available on a common law system, on another system, on a particular case, and having an international law firm working using those tools will be also allowing them to have different jurisdiction, opinion and views and legislation, allowing them to improve their own artificial intelligence being created internally. So that is the level of information, and some law firm in UK has been investing more than £2 to £3 million on only artificial intelligence. That is giving them a competitive advantage. So that is another element that has pros and cons, but it's something to take into consideration.
Thank you so much. And I think these were the two questions that were put in the Q&A. Now I'd like to share a personal thing that I was recently watching a very interesting movie. Now that in that movie, it was shown that it was motor vehicle accidental claim cases. This lawyer goes to every person in the hospital who has got injuries by falling off the stairs or by falling off something, and he will get the authorization letter signed. And he will go and file a motor vehicle claim case, and he would say that the accident was caused by a car. Now the car would always be standing in the police station, and a false FIR would be written, like a false complaint that so and so car hit the person concerned, and a false case will be created with the connivance of all the people involved in the, in the police, in the court, and a false case would be presented, and a compensation would be collected because the car was always insured. Now, if facts are fed in such a manner, there would never be a these are the determinable factors which I think human reasons require to determine a particular case. So I think those are the things that AI should be, this is where we would need to keep a check on the system. And with that, I think there's another question which have been asked, and this question has been asked and the question is that when you talk about data collection, what do you mean? Is it the collection of jurisprudence or legislation? So what is the data that creates the bias? That is, I think, if that is the question.
I think they're talking about the collection of data within the program. So it really depends on what the program is designed to collect. If it's collecting data on people, information, cars, accidents, then that's the data it's collecting. If it's collecting data on personal injuries or medical data on people, then that's the data. If it's collecting data on biometrics, is that the data? And in law, it will be a combination of both contractual terms, contracts, parties, everything that relates to parties. And then if it's for documentation, how that documentation is put together, and then breaking up that documentation in order to be able to see different programs. And then within that, you would have, data in construction industry, data in, and then if you move on to that, as far as jurisprudence is concerned, you could have data in the sense that it looks at the different cases to identify the jurisprudence. And that could be, as I said, when I said you look at the different cases, then you will be looking at the jurisprudence. If you're looking at legislation, then of course you trawl through all the legislation in a particular jurisdiction and look at the legislation, and then that's the data, the legislation with the data. So it very much depends on the architecture of the AI and the LLM, what it's designed to do and what information it's supposed to create. Remember, as far as ChatGPT and others are concerned, it's a creative program. If you want to be specific, like come up with a specific result, not be creative, then of course you'd have to design it to be that.
There is also a kind of testing. I've been testing my name in one of the ChatGPT information collected, and I was born in 1935, meaning that I should be having 89 years now. So, which is of course is not correct. So you can also make the testing in ChatGPT or another one, put your name and see the information coming up, if it is correct, if it is accurate. So that is the kind of data collection that can be happening. We have a system in Rwanda with a fine when you're having a speed with your car. So the number plate and your phone number should be connected. But in the AI system, connecting the fine, the number plate, and your phone to give you the information that you have been, your car has been, you has been put in the system for a fine of X amount, $25 or $50, is not matching. So you may receive a text message telling you that your car has been having a fine in a jurisdiction in the rural area where you didn't move, where you have been staying and your car was in the garage. So those are the data collection that has to be taken into consideration. But the problem is that you have to go, if your plate number has been collected as the one being involved in that, for that fine, you're the one who has to prove that your car you didn't move from your garage. And that is difficult to prove. You have to go and challenge the traffic police for that information. So data collection and the bias that can happen is this kind of a situation. The data collection is also the combination of artificial intelligence in jurisprudence or legislation, but ending up mixing information and giving you a result that is not correct. That's what happened in the jurisprudence given by the US lawyer, who ended up being not accurate. And he was thinking that it's accurate or on the level that he has been providing it in court, with the sanction that has been coming afterwards. So data collection is something that has to be key, that has to be taken into consideration the culture of the jurisdiction, because the culture in Middle East is not the culture in Europe. It may be, there is difference. It's not the culture in Africa. So there is element to take in consideration. So that is the element of data collection. Is not only for jurisprudence, for legislation, it can also be for your plate number and your ID, your phone number, and the information collected during COVID was a lot of information. If put in a system of artificial intelligence, could be combining your test COVID, your phone number, your ID, your medical result, and you don't want those results to be available online or available in the public domain. So that is the information, the data protection that has to be protected in a way. So the data information and the transfer of those information has to be following strict guidelines or strict legislation. Thank you.
Siddharth, I think the additional fact would be that, just like you talked about somebody, the examples that you gave, when they first started using paper, then they'll say, oh, well, paper is very dangerous because anyone can sign it and anyone can create a document. But now with AI, in the olden days, you used to write in stone. It's much more difficult to get the same type of stone and to etch it, and much more difficult to copy. In paper, there is oh, look at this paper. This is quite dangerous stuff. Anyone can copy a document and sign a check, which we did have for many years. But now with AI, I think their level of complexity is grown at many, many different levels and dimensions. And so from what Julian said, I think we need to be more aware. In Hong Kong, every car has a camera and a GPS, so you'll know where the camera is. But your phone also has a GPS. So if you marry the two, you're in the car, unless you left your car by mistake in the car. So there's a lot of evidence available now. So if somebody were to say, oh, you were in some place else, we have many, many, we have many devices. My iWatch, watch, my iPhone, various other devices are constantly recording where you're moving to. And therefore, I think that just adds to the complexity in which we will be living in, and the complexity of evidence that the courts are going to have to face and look at. And so ultimately goes to Julian's point. The AI will be used and will have to be used as a tool to enhance our own ability to assess a large volume of information, but ultimately the discretion, the application of law will always reside in the human brain. And so lawyers are not at risk. Lawyers have to enhance their brain and become even more intellectually savvy than they were before, as will have to be judges as well.
Like, for example, now in India, like in the Supreme Court, you would always find lawyers walking with an iPad, and they will be using liquid, and the judges would have before their screen, like they don't use paper at all now. So everything is just a click away, annexed your P121. So I think like Indian Supreme Court is doing remarkably well when it comes to use of AI in the courts. And I think today's discussion was perfect, wonderful, and it was quite interesting to learn about the new facets surrounding the concept of AI and law. And I thank both Amirali and Julian for today's discussion. And now I would invite Maria to please, come and give the closure remark for today's session.
Thank you very, very much, Sid, for a job well done. I think you've done a fantastic job hosting today, and everyone who's joined online. We started with 53 participants, and now we are at 103. They will agree with me that you've done a fantastic job. Well done. And I also want to thank Julian for a wonderful presentation. I couldn't have been able to capture it any better. I'm actually surprised at how knowledgeable Julian is about technology. Maybe perhaps I haven't had him talking about it for a long time, but I'm really, really quite impressed, and everyone will agree with me that was a fantastic presentation. Thank you very much, Julian. And last but not least, I also want to thank my co-convener, Amirali. Amirali is a guru in these streets. He's used to teaching, and those who felt at ease listening to his presentation will agree with me that the Hong Kong as a jurisdiction has taken some serious steps ahead, and we're really, really grateful to thank, to learn from somebody like Amirali. And, I would encourage those of you who are not yet members of the CLA to please join us, because you can see this was just in a short time. There's a lot of wisdom, there's a lot of knowledge, there's a lot of peer learning, there's a lot of exchange of information. Given that we are all in the Commonwealth practicing the same type of law, we can learn from each other. And last, please join me in thanking the Secretariat run by Bridget, our SG, and with a very able assistants, Evie and Claire, for bringing us together, hosting us through this webinar, making sure we are here, all of us sitting with our nice purple backgrounds. This is all because Evie is very, very particular about how we should look. We hope that you've enjoyed this webinar series. We are going to be back with another 6 episodes. starting soon. We're already preparing for that. So reach out to us at Commonwealth Lawyers Association. You can check out the Commonwealth Lawyers Association online. Our website is up and running. Membership information is available there. You can always email us and get in touch if you want to know more about our committee, the Innovation and Technology. We're looking for new members. We're going to be featured prominently in Malta. So please join us. And as always, we're very, very happy to host you. Take care. Have a lovely day. And thank you, gentlemen, for a job well done. Goodbye.
Yeah.